Have you been told that you need a revocable living trust so your estate can avoid probate? If so, what's the big deal about avoiding probate? And if doing so is so important, why doesn't everyone get a living trust? Hello, I'm attorney Banks Ladd of the Ladd Firm. This short video will help you decide whether you need a living trust, and if not, what other options might be right for your family. Avoiding probate is the main reason for obtaining a living trust. Probate is the court process for titling your assets into the names of your heirs after you die. You can avoid probate by titling all of your significant assets into a living trust while you are alive, so that you have no assets left to go through probate when you die. There are many good reasons for avoiding probate. Probate can cost thousands of dollars and take years to complete. Probate also provides an opportunity for false creditors and disgruntled children to bring fraudulent claims and will contests against your estate that can cost your family thousands and possibly millions of dollars. A living trust is like an open chest. You title all of your significant assets into the trust during life. You are the trustee and beneficiary with complete control for your entire life. You can take any or all of your assets out of the trust while you are alive. Your heirs will become the beneficiaries after you die. Since all of your significant assets are titled in the trust, there is no need for probate. Living trusts can also provide long-term asset protection for your spouse and children. However, trusts created through a will can provide the same protections. Living trusts also offer asset protection for your spouse and children when you die. If you're in a blended family or are concerned that your spouse will remarry after you die, a living trust will prevent your spouse from giving your assets to his or her children or a new spouse. If you have children with addictions, financial issues, or marital problems, a living trust will prevent the loss of your assets to these common problems. The biggest problem with living trusts is that you must transfer all of your financial accounts, real property, and other significant assets into them during your life. Unfortunately, funding can take quite a bit of time and money. For example, you will have to pay for new deeds and recording fees for all real estate. The average cost of funding a living trust with professional assistance is about $2,500. You will also have to be committed to titling new assets into your living trust as you acquire them. An estate will have to be open for any significant assets accidentally left out of a living trust. If you have not retired yet, are still acquiring assets, or expect to inherit assets from a relative, you need to consider whether you will have the time to fund those assets into your trust. We generally only recommend living trusts to people who want to avoid probate, have time to fund their trusts, and are no longer acquiring significant assets. Some states have long, expensive probate periods that are better to avoid if at all possible. For example, due to statutory fees, probating a $1 million estate in California will cost about $50,000. Probating the same $1 million estate elsewhere might cost as little as $2,500. If you anticipate living in an expensive probate state at death and have over $100,000 in assets, you need a living trust. If you don't choose a living trust plan, you will want a will-based trust plan. Will-based trust plans do not require funding and are therefore much easier to create and maintain. When you die, all of your assets pass through probate either outright or into trust for each of your heirs. They also provide asset protection along with many other advantages of living trusts without the difficulties of funding. However, since wills require probate, your estate will be subject to the many perils of probate discussed above. We recommend will-based trust plans to anyone who does not want to spend the time and money to fund a living trust. Some lawyers recommend living trusts for retirement accounts. That is a big mistake. Living trusts are not designed to avoid IRS penalties that can result in the loss of up to half of all retirement assets and the 10-year stretch for children. Also, leaving your retirement assets in a living trust can subject them to the claims of your creditors at death. There are many other problems. A retirement account trust, also called an IRA trust, is always a better choice for retirement accounts. Therefore, if the main reason you are considering a living trust is for your retirement accounts, you should choose a retirement account trust instead. Please visit our website to watch our video on retirement account trusts. If you have questions or would like to know more about our estate plans, please call 251-431-6014 for a free phone consultation. We work with lawyers, CPAs, and financial advisors throughout the United States to ensure that our plans comply with your state's requirements. The consultation is free and there is no obligation.